Okay, good morning, everyone, or good afternoon for some. I'm Ann Massey Badmus with Sheaf and Stone, and I'd like to thank you all for taking the time to attend this presentation. And we hope it will be very informative and helpful for you. Before I go any further, I just want to make sure that you can hear me and see me. So if you can, please just type in the chat pane, yes, I can hear, or just type yes. Okay, perfect. I'm getting some responses there, so that's great to know. Okay, so we're here today to talk about the green card process through what's called the EB-1 category, employment-based one. And so I want to take some time to kind of give you some information and basic information about that. But before we do that, I want to let you know that you can ask questions at any time during this webinar. And the best way to do that is to go to the questions panel just below the video. So if you scroll down, you will see a section that says ask a question, and that is the best place to put in your questions rather than the chat window, which is just more for technical difficulty. If you have any technical difficulties, then go ahead and use the chat window. But if you have a specific question about the presentation, then please use the ask a question panel just below the video. So with that, you can type and send your questions at any time. And we're going to, as we go along, if I see questions that are, there, I'll try to answer them during the presentation, as well as during the Q&A session at the end of the presentation. So one thing I do want to remind you is that if you don't get your question answered today, then you're welcome to send me an email and we'll try to answer your question that way. Or you can contact us to speak with me for a private session. But to maintain confidentiality, we're not going to reveal any, we don't want you to reveal any personal information during the Q&A session. All right, so here's just some information about you for those of you who don't know me. I'm Ann Massey Badmus, as I mentioned, and I am an attorney who's been practicing immigration law since 1993, working with thousands of clients through the green card and other visa process. Worked with many people in the EB-1 process, and so that's what I'd like to talk to you about today. So our agenda is, first of all, we're just going to give an overview of the employment-based immigrant visa quota system, just to give you some background or confirm your knowledge about how that quota system works for employment-based green card applications. Next, we're going to talk about just the nuts and bolts of how the three categories that we're going to discuss today about EB-1, what you need to do, what you need to qualify, some of the information that you need to gather, just to give you basic information about how that process works. And then we're going to talk about the actual green card application procedure if you decide to apply through the EB-1 process, what that looks like and what your expectations can be as far as the timing and timing of that whole process and what steps along the way that you can encounter during that process. And then, of course, we'll give time for any additional questions that we haven't answered during the session. So again, we're going to talk about green cards, and it is somewhat a maze to many people, somewhat a way you have to just kind of figure out how to get through there. And that's what we're here to do, is to help you to try to see what's the best options or the options that are available for those who are interested in getting green cards in the U.S. So as I mentioned, we're going to talk about EB, which is employment-based green card annual quotas. So the government a long time ago decided that there's going to be a limited number of green card applications through the employment categories. I've listed here 4 different categories. There are actually about 6 of them, but they don't really, the other two are just not really relevant to our discussion today. But what I wanted to show you here is how that process works. The green card quota is basically a line, the line that many people might refer to, where those who are able to apply for the green card through employment sponsorship or employment or through work in some way, get a ticket to stand in line in order to get the green card eventually. So the system is called an immigrant visa system, which immigrant visa is essentially the green card itself. So As you can see, for the EB-1 category, which is what we'll talk about today, it's called the priority workers category. And out of the 140-some thousand visas that are available for immigrant visas that are available each year, there are 40,000 allocated to the priority workers category. Then we have another 40,000 for the EB-2 category and an EB-3 category, and then finally the EB-4 category. What's important about the priority workers category is that those priority workers are the ones that are first allocated immigrant visas. So first they look at filling that particular category and if there are any visas left over, then it kind of flows down to the other visa categories. So that's why you will see in the EB-1 category, as we'll show later, that there does not generally tend to be a waiting list for almost everyone, no matter what country you're from. So that's a real advantage for those who are in countries that do tend to have a long line, like India and China and some other countries in the EB-2 or EB-3 category. So some facts that it's important for you to know in terms of how, because oftentimes we get the question, well, how do they determine how many visas are available through the EB green card annual quota? And it's a complicated formula, and the Department of State is the agency charged with determining when they will know that they have enough immigrant visas available. But generally, there's no more than 7% of visas may be issued to people belonging to any one independent country in a fiscal year. That doesn't mean there's a max. That doesn't mean that every country gets 7% of visas, but what it does mean is that there's a maximum number. Generally, the visas are sort of spread out evenly among all the countries in the world, but any one country can't have more than 77% of the visas. So that's why you will see in larger countries like India and China, where there are more applicants, they pretty much reach that cap of 7% pretty quickly, and that's where you get that backlog, that quota that you see. It's also based upon, one thing you need to know is it based upon country of birth and not citizenship. So sometimes we'll get the question, well, I'm a Canadian citizen now, so does that take me out of the born in India queue or the born in China queue or some other queue there, or quota there? And most of the time it does not. So even if you are now a citizen of a country that generally is not backlogged or does not have a long waiting list, if you were born, they're going to go by country of birth. So that's the relevant question: what country of birth, or what is your country of birth, to determine where you're going to be in that line. And then also keep in mind that when they allocate or decide these visa applications, determine how many visas, immigrant visas are available, they're also including spouses and children who are dependents of the primary applicant. So if you are applying for an EB-2 or an EB-1 category and you have a spouse or children, let's say, for example, you have yourself and spouse and 2 children. So your application will actually take up 4 visas in the EB-1 category. And that's why it does tend to, again, sort of get backlogged for some countries, because they're not only including the employee or the actual applicant, they're also including family members in that determination of how many visas are available. One last point I want to make about this is what's called cross-chargeability. And what that means is that if your spouse has a different country of birth, so for example, if your country of birth is one of the countries that is backlogged, like India, but your spouse has a country of birth of Canada, then you can actually bypass the Indian line and go to the Canadian line, which generally is not backlogged. So that's why it's important to look at also not only your country of birth if you're the primary applicant, but also what is your spouse's country of birth. This is particularly helpful if you are in the EB-2 and other categories for nationals of China and India that tend to be backlogged. So that's a tip for faster processing, that if your spouse has a different country of birth, it might be helpful to you in terms of moving through the green card process faster. All right, so So just to kind of, again, look over the how that process works, we often get questions about the visa bulletin, and many of you probably know about the visa bulletin. About a year or two ago, the visa bulletin changed a little bit in terms of how the visas were announced, in terms of whether someone's eligible to get the green card approved or eligible to actually start the green card process. So it's important to know that immigrant visa, or the quota, not only applies to when you actually can be approved for the green card, it also applies to when you can actually apply for that last step of the green card process, which will either be applying at the U.S. Embassy for the immigrant visa, or if you're in the United States and qualified, you can apply through the adjustment of status process, which we'll discuss later. So with the changes that were made with the visa bulletin, the Department of State visa bulletin a few years ago, they decided to, instead of having just one chart that explained what was the date that someone could actually apply, which was the same date that someone could apply for as well as get approved for the green card, they decided to split up the dates in two ways. One was the application final action dates. And what that basically means, that if your application is in process, then that is the based on the numbers or that they're showing on that chart, you can actually be approved for the green card. Then you also have the dates for filing applications chart, which basically says that even though you cannot actually be approved for the green card, you are now eligible to apply or start the process to finally get your green card. So either you can go through adjustment of status or through the immigrant visa process. What's important to note here is that the dates for filing applications chart is really a chart based on those who are going to apply outside the country through the immigrant visa process. So if you are applying outside the country, then the dates for filing applications chart would apply to you in terms of determining when you can actually start submitting your documents to the National Visa Center. So it isn't necessarily a chart that can be used for the adjustment of status process. That is going to be determined by the Department of Homeland Security or the USCIS. They are going to determine whether or not you're going to be able to use the application final action dates chart or the dates for filing applications chart to apply for adjustment of status in the United States. So just a quick look at what we're looking at now for June 2018 with the Department of State Visa Bulletin. It may not be very clear here, but I took sort of a screenshot of the final action chart for the employment-based categories. And as you can see, for the left column are the different categories, including EB-1, which is the first line there. And as you can see, for all chargeability areas, the first column except those listed, what that means is anybody who is not in the born in China, El Salvador, India, Mexico, Philippines, Vietnam chart, a column. So if you're not in any of those, or if you're not born in any of those countries, then you're going to be looking at the all chargeability areas column. And right now for EB-1, that means it's still current. So those who are applying for EB-1, they can apply immediately for adjustment of status based on the fact that this is a current approval date. There is no backlog. So those who are already in the process, have already applied for adjustment of status, can be approved, assuming that all the other processing has been done. They can now be approved for the green card as well. But as you can see, if you move over to the right to the China and to the India columns, there is a cutoff date. This cutoff date means that those who have actually initiated their EB-1 process before January 1st, 2012 are now able to apply to be approved for the green card if they are already in the adjustment of status process or if they've applied outside the country. But also they're able to file the adjustment of status application immediately as well. So for example, if you've just started the green card process, you've not applied in the past for any other category like EB-2, and you don't have a what's called priority date, a date of application, then basically you were going to be just starting out. So that means that if you apply today, your priority date would be May 16, 2018. And if you are born in India or China, as you can see, even though you might be approved for the EB-1 category, at least being determined as qualified, you will not be able to apply for adjustment of status until the government gets to your date, which would be January 16, 2018, per the example. So we have many clients, of course, who have applied more recently and have a priority date that's after January 2012, which means that they still are in the queue for applying for the adjustment of status. Now, fortunately with EB-1, generally we have noticed in the past few years that there has been times when it has backlogged in this sense, and there has been a waiting list, but generally in October, when the new numbers are available, it goes back to being current. So it does, EB-1 still tends to be a faster process for most people who are in the China or Mexico, I'm sorry, China or India line. The next chart is the dates for filing. And again, this would really apply if for adjustment of statuses purposes, it generally does not apply unless the Department of Homeland Security, the USCIS, says it does. So as you can see, the dates for filing, sometimes people will look at that and ask, well, it looks like it's current at EB-1, so why can't I apply for the adjustment of status right now? But unfortunately, this isn't the only chart, or this isn't the only agency we have to look at to determine whether or not you can apply for adjustment of status. What you have to do if you're in the United States and you want to apply for adjustment of status is go to this website I have listed at the bottom, uscis.gov/visa bulletin info, and look to see whether or not they are using which chart they're using from the Department of State. This is from the USCIS website, which states that if they will indicate whether you will need to use the application final action dates or to use the dates for filing visa chart. And currently, at least in the employment-based category, the USCIS has consistently been using the application final action date chart, which means that generally most of the time, if your priority date is not current, if you're in one of those backlogged area from China or India, then you would not be able to file until your priority date becomes current. All right, so that's just sort of short summary, or it took some time to go through the visa process. But now we want to discuss the EB-1 options for top professionals. So this is sort of the nuts and bolts, and I will go through each category. We have 3 categories of EB-1 priority workers. We have extraordinary ability, which is EB-1A, the outstanding researcher or professor category, which is EB-1B, and then we have the multinational manager or executive, which is EB-1C. So each of those, although called EB-1, they have very specific requirements. So it's important to know exactly which requirement might, or which requirements or which category might be most applicable to you. So we'll start out with the EB-1A category, which is the extraordinary ability. The main things to consider about the EB-1A category is that it's ideal for those who don't have an employer sponsor. So because no employer sponsorship is required. In fact, you don't even need to be in the United States. We've worked with many people outside the United States who have qualified and been able to come to the US with the green card because of the EB-1 category. So that is one advantage. So for example, if you feel like you're qualified, but you don't have an employer yet, or you have an employer who's not willing to process the green card for you, EB-1A is the perfect category if you qualify qualify otherwise. It is also important to show that even though no employer is required, you must show some prospective ability to actually be employed. So having a job offer or offering to or considering, considering self-employment. There are different ways to go about that. So it's not necessarily difficult that even if you don't have a job offer, it's still possible to apply for the EB-1 category. The other thing is that any occupation can qualify for EB-1. So we've worked with researchers, physicians, musicians, artists, athletes, entrepreneurs, any occupation, religious workers as well. So you can keep that, you should keep that in mind as well, that there's not any specific occupation restriction at all. But the most important thing is that you as the applicant must show through the evidence that we'll talk about that you have risen to the top of your field on a national basis or internationally. Now so it's nationally or internationally. So what you want to keep in mind is that generally you want to go for the lower standard of nationally as opposed to trying to show you're nationally recognized in your field. But what's also important, and sometimes I get this question as well, do I have to be nationally recognized or do I have to have a lot of support from people in the United States? And the answer really is no. What we're looking at is where are you most well recognized? If you have sustained recognition and are considered outstanding in your field in your own country. For example, just spoke with a client, potential client this morning that talked about his work in Mexico, where he is very well known in Mexico, but not necessarily well known in the United States. Well, that's where we're going to focus. We're going to focus on the national recognition in your home country or where you are well recognized. So even if you haven't worked in the United States and most of what you've done is outside the United States, you can still be qualified. But of course, if you have worked in the United States and that is your primary area or primary country where you have done most of your work, then we have to qualify you on the basis of national recognition in the United States. So that being said, you must meet 3 of 10 criteria, and we'll go through those 10 criteria. But if you are one of the fortunate ones who have won very well-known international prizes, such as the Nobel Prize, the Pulitzer, an Oscar, or an Olympic medal, or something in the similar category, then you don't have to worry about the 3 criteria. You can simply just show your Nobel Prize and you will get the EB-1 category. So that's fairly easy, but in most cases, most people don't meet that criteria. So we will talk about the 3 or the 10 criteria that are required to be considered when you're applying for the green card through EB-1A. So the first category is awards. And keep in mind when we say awards, we want to show that you have national or international recognition based. So your award needs to be nationally or a national recognition. Not a local recognition or a regional recognition or a recognition within your own employment. Those don't generally qualify. So it's important that if you do have awards, we certainly want to know about them, but we have to determine whether they qualify by looking at what is the character of the award. Is it awarded by a national organization or an international organization? And keep in mind, it needs to be a professional organization within your field. Some other things you want to look at if you're questions you want to ask if you're considering the EB-1A category and have some awards. You're going to need to prove what is the criteria for the award. How did the organization that gave you the award determine who would receive the award? So typically what we would look at is if there are bylaws or there's award criteria criteria that's published, we'd want that. But if there's not published criteria, then you more than likely will need a letter from the organization that explains the criteria and shows that it's a competitive award. They may also need to provide previous award winners. Oftentimes the government asks, well, we want to know how prestigious is this award and who won this award in the past and let us know what their background is so we can kind of compare to see if it is really a prestigious award. And that also goes to the question of how many people competed for the award. Were there hundreds of people who were considered or applied for the award, and only 10 received the award? So that's going to be important too, to determine how strong or how prestigious that award is. And then you may also need to provide information about who are the judges for the award, who determines whether someone gets the award. We want to know who these people are. The government wants to know who these people are and whether they are well-recognized individuals, which kind of gives more weight to that award being a very prestigious award. Oftentimes, most of the time, awards are not a category that we meet that often, but again, we only need to, at minimum, meet 3 of the 10 criteria. So if you don't have an award that kind of meets this category, doesn't mean that you couldn't proceed with the EB-1 application. The next category is membership in associations which demand outstanding achievement of their members. And again, it's kind of repetitive, but it's very similar to the awards criteria. So some of the questions that we ask about your memberships would be, is it a regional, national, or international professional association? And what is the criteria for that particular membership? Sometimes professional memberships only require that you have a degree in that particular profession and pay your fee. Well, that wouldn't qualify as a membership which requires outstanding achievement. However, in some organizations, you might have different levels of membership, and certain higher levels might require you to prove some outstanding achievement, such as publications, service to the community for a certain extended time. There are different criteria. So when you state that you have these memberships, we're going to look at the criteria and see if we can find memberships that actually do require more than the minimal requirements of being a member of that profession. So again, the government will also, because they don't know all about the associations that you might be a member of, and if you're going to claim that it is a membership that demands outstanding achievement, then they're going to ask the question sometimes of who are the current members, what are their backgrounds? If it is such a prestigious membership, they might want to look at whether the members themselves also are very well recognized in their field. And then again, similar to the awards category, who are the individuals that are determining membership eligibility? Who evaluates whether or not you're qualified for the membership? So those are things that you want to think about if you're thinking that this might be a category that you could meet. And oftentimes, it just requires some evaluation. And if you meet with us, we will work with you to determine whether or not these memberships would meet the minimum criteria for our minimum requirements for this particular criterion. The next criteria is articles about you. This is publicity about you in either a professional magazine or professional journal or publication, or even online, or other major media, which would be, could be a newspaper, it could be, again, online as well. It may not necessarily be a professional publication, but it could be the New York Times, for example. It doesn't have to rise to that level, but that's just an example. So let's say if there's an article about you in the New York Times, about your professional work in the New York Times, and that might qualify for this criteria. So again, some of the questions to ask if you're looking to meet this criteria is, these articles or article that is written about you, is it a regional publication, is it a national one, or is it an international publication? So there we need to have more information about that actual publication. How popular is the publication? So there's a lot of this information is pretty much online. You can research and find that, but these are the questions that need to be answered. How many subscribers does it have? How wide is the circulation? If it's an online article, how many page views does it get? How many page views did it get? Those are things that will help to strengthen your ability to meet this criteria. And what's really important, because sometimes we'll get articles that may talk about some of the work that you contributed to or some research that you contributed to, but it may not name you specifically. And sometimes that can be problematic. Ideally, if the article talks about you and your work, that's the best case scenario. But if it doesn't, does not mean we could not use that article, but we will have to somehow trace and show that you actually participated in that work and you made contributions to the work that's being described in the article itself. The next criteria is judge of the work of others in your field, either individually or on a panel. So this is where they want to know whether or not you've been asked to determine the qualifications or how the strength of the work of others in your field. Typically what you're looking at here is that either you were serving on a panel as a reviewer of someone's publication, if you're in that kind of scientific field or medical field, where you've acted as a reviewer or an editor or a similar role. But it could also be if you're in athletics, you were judging a athletic competition like in ice skating, for example. That could be another role that could fit. So we will, as we look at your CV and discuss with you your qualifications or your work that you've done in this capacity, we will kind of get an idea of whether or not this would meet the criteria. But what's important is if you did meet the criteria, just having one, let's say, for example, you are a reviewer for a publication or journal, a medical journal, for example. Just being named as a reviewer and not actually reviewing any papers would not qualify you for this criteria, although technically it does, by the terms of the language in the law, it would seem that it does, but the USCIS generally does not find that you meet this criteria unless you actually did review someone's paper or actually serve in that capacity rather than being named as a judge in the future. So it's important to track any of the reviews. First of all, it's important to at least review one paper or more, at least review one, but ideally you would like to review as many as possible, because the more you can show, the more times that you served as a reviewer, the stronger this category becomes for you. So it's important to look at that as well. I can't say that there's a specific number of reviews that you need, but I would say that you would probably, want to look at having at least 5 or more actual reviews before applying for the EB-1 if you're going to use this as one of your categories. And in addition to that, if you are frequently asked to be a reviewer or an editor or to judge the work of others, then that's a good thing too. So even if you haven't agreed to serve as a judge, but you have received several invitations, then we do want to know about that as well. That will be a plus in addition to the fact that you have actually served as a judge or as a reviewer in your profession. The next category is the original scientific, scholarly, artistic, athletic, or business-related contributions of major significance to the field. This one is the one that's probably the most difficult to meet, but this is where it's very important to define your area of expertise. So if you're in the medical field, for example, if you're a cardiologist, we don't generally want to look at the whole of cardiology. It would be better to narrow down your field. So if you are a cardiologist, but you've done research in a specific area of cardiology, then we want to say that that's your area of expertise. And that's where you've made the most contributions to your field. And that's where you may have made any discoveries or new methodologies or had some case reports or things that have influenced the practice of cardiology in some way in that specific area, or dealt with a specific condition that you feel you have, or disease that you feel you have contributed to. So the government's going to want to know, well, what is the impact of this work that you've done, this discovery? For example, if you've made some certain discovery, they want to know what's the impact of that? How does that affect your field and how does that improve healthcare, for example, or improve the scientific research in some way, improve the business model that you have or the business model that people are following. Those are things that they are going to look at. Have you been invited to present your work or teach others about things that you've done at conferences or professional meetings? Those are all helpful to show that you could meet this criteria because you've made some contributions of what government would consider major significance. And this is where, as most of you probably know, recommendation letters really are important. Even though the government doesn't rely solely on the recommendation letters, it is important to have good recommendation letters that can talk about, from experts who recognize the work that you've done and can speak to how that work has help the field in general, or even help their own work in the field, different things, different aspects of the field as well. So it's very important to have good recommendation letters. And normally the government doesn't want to see tons of recommendation letters because they're not going to want to read through all of them. But generally, if you get 5 to 7 good recommendation letters from people who are credible in your field, then this is a criteria that you may be able to meet. The next criteria is authorship, meaning you've written scholarly articles in your profession. Either the articles were published in professional journals or publications or other major media. Major media, again, being things like magazines, newspapers, online. And again, they're going to look at how well distributed, because keep in mind that the government is looking at national recognition, at least national recognition. It could be international, but at least national recognition of your work. So if it's a publication that is only in your city, it may not, but not, spread out. It hasn't been distributed to people throughout the U.S., for example. Then that article that you wrote may not be considered as strongly. It will be considered, but it may not help you in the next determination that we'll talk about, which is the final merits determination. So if you have articles in nationally distributed publications, then you're going to have a stronger case than if it's a local publication. But speaking to that, they're going to want to know how popular is that publication, how many subscribers does it have, what's the impact factor, if it's online, how many page views, downloads, visits, those kinds of things going to be important as well. And so again, these are things that we would look at if you're talking about publications. We want to get kind of a real understanding of the strength of those publications to show the government that these publications are strong enough to show that you have risen to the top of your field because you've published in very prestigious journals, for example. The next criteria is performance of a leading or critical role in distinguished organizations. This category can apply to any field. And what we're looking at here is for you to show that, first of all, the company or organization or practice that you worked for is very well known, has won awards, if we hear that company's name in your field, it's just just an outstanding company. So the fact that you've worked there, number one, could be important. Number one has to be shown that that organization is outstanding in some way. So how we look at that is we want to look at its ranking among similar organizations. For example, for some universities, they're ranked in, of course, universities are ranked and other organizations are ranked, but universities is an easy one to talk about, where in U.S. News and World Report, we might look at that publication and see what they're saying is the ranking of the university that you worked with. Of course, if it's in the top 10, that's great, but even if it's not in the top 10, we can still use it because there are many, many universities, many, many organizations, and so we'll look at that and determine, how we can show that that organization is outstanding, or it might have won regional awards for its work. So those are things that we're going to look at. But next, you really, even if the organization is outstanding, so for example, if you're an employee at Harvard University, and of course, certainly, the government will certainly agree that that's an outstanding organization, they're going to want to know what is your role in the organization. How is that a leading role or a critical role? So that's where we're going to have to look at the organizational hierarchy. Where are you as an individual working in an organization? Are you a director of a department? Are you president of the organization? Those are different things that we're going to look at. The leading role is a little more difficult for to establish for those outside of performance arts. For performance arts, it's pretty easy to say this is a leading role in a play or something like that, or in a entertainment organization. But if you are not, having that kind of leading role, it doesn't mean you can't qualify. What we're going to look to then is whether your role is critical. And the critical role, the way the government looks at that is, what impact does your role have on the organization as a whole? Oftentimes we think, certainly if you are a professor in a university, that should be a critical role, since of course that's absolutely necessary for the operations of the organization and the esteem of the organization to have great, outstanding professors in their organization. However, the government doesn't necessarily look at it that way, so they're going to want to look at whether in your role, what are the things that you've done that make you stand apart from other professors, for example, in the organization. So again, if we're trying to meet that criteria, we're going to look in depth into your performance in the organization, whether you've served on committees, whether you've been influential in the way the organization sets policy. Different things like that are important to show how your role might be critical or even leading. The next criteria is the extraordinary ability. Is the high salary. This one is fairly easy to establish if your salary is above, or your compensation is above the national average. So what we're going to look at is what has been your total compensation in the last year before applying, or if you if your compensation isn't, doesn't meet or doesn't exceed the average salary, but you have a job offer that you are planning to accept, and that salary is well above the national average, then you might be able to meet this criteria as well. So we'll have to do some digging on your specific occupation and look at the statistics out there to determine whether your salary is above in the highest percentiles of the field. And then these last three categories are pretty much sort of not necessarily ones that will apply to everyone, but I did want to sort of touch on them. I think most of our audience that we have on the webinar probably won't meet this criteria, because the criteria is really geared towards those in performance art. So as you can see, there's criteria number 9, which is your work has been displayed at artistic exhibitions or showcases, or number 10 is you have commercial successes in performing arts. So if you are in the performing arts, these might be categories that certainly, or actually these would be categories that you would want to meet in order to qualify for the EB-1 category. There is also a sort of catch-all category or catch-all required criteria that you could use. So if you don't meet some of the other criteria, but you have some other evidence that you think is important to your occupation that shows or could be considered to show that you have recognition or considered extraordinary in your field, then you can do that. So for example, in the coaching, someone is a coach, an athletic coach, and they may not meet some of the other criteria there because it just really isn't applicable to their occupation. We might present the successes of their athletes that they've coached or the successes of their team as saying this is comparable evidence because the team or the athlete has achieved phenomenal success through the coaching of this individual. That is proof of the coach's extraordinary ability. So this is sort of a catch-all, doesn't necessarily apply only to coaches, but this could be something else that we could look at if you don't have, or even if you do have if you do meet most of the other criteria. It might be something that we want to bring to the government's attention, that, hey, you need to consider this as well to determine whether or not I'm of extraordinary ability. So next I want to go on to the outstanding researcher or professor category, and some of this will be very similar to the EB-1A criteria that I discussed, but it is very different in very important ways. As I mentioned with EB-1A, you do not need an employer sponsorship. However, with EB-1B, you do, and it's a very specific employer sponsorship. So the employer must agree to apply for the EB-1B for you. So a bulk of the paperwork is signed off by the employer. But also your employment must be with either a university, or if it's not with a university but with a private company, it must be a company that has at least 3 researchers and has attained some recognition in the field. So for example, if you're working with a pharmaceutical company, which has researchers, and they've been known to produce certain drugs that are very well distributed throughout pharmaceutical drugs that are distributed throughout the world, then you probably be able to apply for outstanding researcher through that company. So this again is very specific criteria that's only so not many will be able to apply for EB-1B unless they're employed through this means. But let's say if you are qualified, you are a university professor or assistant professor, or you work for a company that does research, a research company, then this could be an opportunity for you to apply for EB-1B. It applies to researchers and professors only. And what the requirement is that you have at least 3 years of experience in the field. There is a little caveat to that. If you don't have 3 years of experience, but you have a PhD, and during the time that you worked on your PhD, you had several publications, for example, and your work was well recognized during the time of your PhD studies, then you may still qualify for the EB-1B category, even though you may only have 1 or 2 years outside of your PhD in terms of experience. And then finally, the next criteria, which is a little bit different from the EB-1A, is that you must show that you're recognized internationally as outstanding in a specific academic area. So, as I mentioned before, for EB-1A, the recognition is it can be internationally or it can be nationally or internationally. So you don't have to rise to the level of international recognition for EB-1A, but for the EB-1B, outstanding researcher, you do have to show international recognition. So we'll talk a little bit about that as I go through the criteria. There are only 6 criteria for the outstanding researcher category. So it does tend to have a higher rate of approval than the EB-1A category. But again, it only applies to certain applicants. Out of the 6 criteria, you must meet 2 of the 6 criteria. So we'll briefly go through the 6 criteria. Again, much of this is the same as the EB-1. There is the awards category, same as we described in the EB-1A. They're going to look at the awards, and you're going to have to provide information about the awards. What is the criteria? Who are the previous award winners? How many competed? All the same that we talked about with the EB-1A, you will have to do for the EB-1B if you're going to use an award or a number of awards as a basis for meeting the EB-1B category. The other category, very similar to EB-1A, is membership in associations that require members to demonstrate outstanding achievement. So they're going to be looking at the criteria for the memberships. Who are the current members? Is it an international professional association that you're a member of? So that's important as well. Publish materials and professional publications written by others about your work. If you recall, or if you were listening in previously, in the EB-1A category, there was a criteria about articles written about your work. This one is a little different in that this has to be, your articles written about your work has to be done in professional publications, not in newspapers, other online sites that are not professional within your field. And of course, it has to be about your work. So it's important to show that the article describes your work, and if possible, names you, and if it does name you specifically, that's the ideal publication about you that could be used to meet this criteria. The other criteria, again, is the judge of the work of others, very similar to the EB-1A. So you have to be show again that you've judged the work of others, either as a reviewer, editor, or similar role, and perhaps you've received frequent invitations to judge. Another criteria is original scientific or scholarly research contributions in the field. This is a little different from the EB-1A requirement that you show major contributions to your field. And the reason it's different is you can see that the terminology here is showing that you had original scientific or scholarly research contributions. You don't have to show that they were major contributions, which is really an advantage to those in this who are applying in this category. So what's important to show, again, is what is your specific area of expertise, narrow it down as much as possible, and show that the research is original or novel. You can show the impact of your research, and that's to help strengthen this category, but it's not, the focus isn't so much on the major significance, but the fact that it is original, it is an original contribution to the field. The next criteria is authorship of our written scholarly articles or books in international professional journals. Again, this is, if you have articles or book chapters or books that you've written, you need to show that they are internationally distributed and that they are professional, they're actually professional publications. So again, we're going to look at how popular is the publication, where is it circulated, do we have subscribers in other countries besides the US, or if the publication was in another country, does that publication reach beyond those countries' borders? And then it's very helpful to show how often the article has been cited or has been read or used for further research. So just to summarize the EB-1A and EB-1B categories, it's a two-part analysis. So I've gone through the criteria for EB-1A and EB-1B. As I mentioned, for extraordinary ability EB-1A, you need to meet 3 out of the 10 available criteria. For EB-1B, you need to meet a minimum of 2 of the 6 criteria. However, that's not the end of the evaluation by the government. Even if they determine that you did provide evidence to meet 3 or more of the criteria, or 2 or more for 2 or more of the EB-1, there is a subjective second evaluation called the subjective, the final, they don't call it the final subjective, but I call it subjective in the sense that it's called the final merits determination. And it really is up to the officer looking at this application to determine whether or not they believe that you have sustained national or international acclaim or recognition in your field. So it's really the best way, we believe, to meet this subjective final merits or pass this subjective final merits determination is to have as much evidence as possible to meet the 10 criteria or the 6 criteria. So as I was mentioning, if you are a reviewer, a journal reviewer, well, we don't want to say you reviewed 1 journal article. Although that will help you meet the criteria, it may not help you meet the subjective final merits determination. So if you had 10 articles that you've reviewed and you're constantly invited to review for other people, that's going to make that really strong and kind of give the officer the feeling that this person is really in demand. that shows that yes, there is national recognition or international recognition. If you've written 1 or 2 articles, that will meet the criteria, but again, having more articles will help you overcome the subjective final merits determination. So those are the things that when we evaluate your eligibility, we're going to look at and talk with you about to determine whether or not we can meet this, have a good chance of meeting this final merits determination. So the last category I want to briefly discuss before we just go through the final part of how the process works for EB-1 green cards is the multinational executive or manager. This one really, again, is very, very specific. And for those on the call, it may or may not apply to you, but it is really something that someone can consider if they are an employee of a multinational company, or if they're a business owner outside the US and they plan to continue their business, but they want to start a new business in the United States, or they're operating a business in the United States as well and want to transfer here to the US in order to develop and operate both businesses, the one in their home country or in the other country, and the one here. So this could be actually a good alternative for many to the EB-5 immigrant visa category, because there's really not a minimum investment amount needed. But just to briefly summarize what the requirements are, basically if you're going to qualify for the multinational executive or manager category, then you need to have a business here in the US for at least 1 year, or an employer that's been operating in the US for 1 year, and they also have a foreign company that's been operating for at least 1 year as well. I won't get into the details of how this qualification happens, but it's important to know that you're dealing with 2 companies, a foreign company and a US company. So this applies to top level managers and executives, and that's important to qualify how they are considered to be top level. So it's very important to look at what the position is within the company to determine whether or not they are an executive or a manager. And then finally, the person who applies for the EB-1C must, or the employee that's applying through the employer for the EB-1C, must have worked with the foreign company at least 1 year in the prior 3 years before they can actually apply for this visa or this green card. All right, so next we're just going to go on briefly through the process for applying for EB-1 green card. Step 1, of course, is to apply for the I-140 petition for immigrant worker. I'm sorry, I thought I had it on the slide, but the actual form number is I-140 petition for immigrant worker. With the I-140, this is where you prove your eligibility for whatever EB-1 category that you're applying for. So all the evidence needed to meet the criteria that we discussed needs to be included. So I've included this picture of this binder because usually it's a stack of evidence. We're going to include copies of your papers, your articles, your reviews, your CV, of course, your background as far as diplomas, all the evidence that we can to show that you're qualified for the EB-1 category. If you are applying through the EB-1B, outstanding researcher, or the EB-1C, multinational executive, then your employer must show that they have the ability to pay your salary. And so they do that through providing either tax returns, or if they're a large company, they just basically have to say, yes, we can pay. But if they're a smaller company, meaning having fewer than 100 employees, then they're going to have to provide tax returns or audited financial statements, and maybe some other financial records as well to show that they can pay your wage. For the EB-1A and the EB-1B categories, you do have the premium processing option, which means that the application can be processed within 15 days of application. If you do not use the premium processing application, generally we're seeing about 6 months or more for the decision for the EB-1A and the EB-1B category. So as I mentioned before, if you're an EB-1B and EB-1C category, then you need to have your employer provide this information shown on the slide to prove that they can pay your salary. Step 2 is the immigrant visa application. And so important to note that, as we discussed earlier, your priority date must be current in order, meaning that there's an immigrant visa available in your category. EB-1 in general, usually there's really not a waiting list, but as we discussed earlier, for India and China, currently there is. That will probably improve by October. But in any event, before you can actually apply for the immigrant visa immigrant visa, you're going to have your priority date current. So the immigrant visa application has 2 processing options. You can apply for adjustment of status in the United States, as we discussed. If you have valid legal status in the United States currently, or at least have not been out of status more than 6 months, then you can apply for adjustment of status in the US. If you do not qualify for adjustment of status, either because you are out of status here, or you are outside the US anyway, then you will apply through the immigrant visa process at the US Embassy using Form DS-260. A quick fact to address is that for the J1 waiver physicians, even though you may be approved through Step 1 for the EB-1 or EB-2 category, whatever category you've applied for, you must still complete your 3 years of medical service before you can apply for the immigrant visa. This is the case for all J1 or J1 waiver physicians who are applying or who received a waiver through the Conrad 30 program or other government-sponsored waiver program. All right, and so as part of the adjustment of status process, if you are applying for adjustment of status, you have to be eligible, you have to be present in the United States in a valid non-immigrant status like H-1B, for example, and you have not had any violations of your status for more than 180 days. So, for example, you have not worked unauthorized, you don't have any more than 180 days of unauthorized work, or you are not overstaying for more than 180 days. So not that we're encouraging anyone to be in that situation, but if you do happen to be that situation, you may still be able to apply for adjustment of status if you've not had status violations for more than 180 days. The I-485 application is filed separately for you as the applicant, as well as your family members who qualify. And as part of the process, typically you will receive an employment authorization document, EAD, and an advanced parole document. Excuse me, losing light here. Okay, and an advanced parole document that will allow you to travel internationally. One thing that's kind of changed in the past year or so under the new administration or the current administration is that even if you have an H-1B visa stamp, and are eligible to travel in H-1B, if you've applied for adjustment of status, you still have to wait for the approval of your advanced parole before you leave the U.S. If you leave the U.S. and before you've received the advanced parole, then your application can be considered, your adjustment of status application can be considered abandoned, which means you would have to reapply again. Processing time for adjustment of status is currently 12 to 18 months. It could be faster. We have people who've been approved faster. We've had people who've taken longer. There really is no rhyme or reason to it as far as why someone who might have applied after you might get a approval before you. It really is mainly, unfortunately, it's not a situation where the government always processes in order. But we have no idea why in some cases they just process some others faster than some. So, but on average, you can expect 12 to 18 months to process for the adjustment of status application. The approval of the adjustment of status means that you are approved for permanent residence. The current procedures for adjustment of status is that all employment-based applicants, including EB-1, have to go to an interview with the USCIS immigration officer at the end of the process, and before approval can happen. And it will normally, the adjustment of status application, the interview will take place in your local office wherever you currently live. But that is usually the last step. So if you get a notice saying that your application has been moved over to the Missouri Service Center. What that means is that they are now putting it in the queue for scheduling an interview. And usually not much later, you will get a notice saying you have an interview, which typically is they usually give you about a month's notice for the interview. As part of the interview, part of the process, we help our clients prepare for that. So, definitely if you have an attorney, once you get the interview notice, that attorney should help you with getting prepared for the interview and letting you know what you need to expect and what you need to bring to the interview as well. If you decide to go through the consular process, or you have to go through the consular process, then that's a different procedure altogether. It will require, if you're in the U.S. and you decide to go through the consular process, you will need to attend the interview at the U.S. Embassy in your home country. You generally do not have a pick of where you can get your consular process done. The government will normally require you to go to whatever country you're a national of. If you have permanent residence in a different country than your country of birth, you can probably apply there, or citizenship in a different country than where you were born. You can apply for the immigrant visa there. But if you don't, you will have to go to the country in which you were born in order to process for that. And processing time generally takes about 6 months or more at the U.S. embassies. So tips for faster processing. You need to determine whether or not you should go through adjustment of status or consular processing. That's something you would talk with your attorney about, because oftentimes it may, consular processing may not be an option, or it might be the only option for you. So that's something to discuss with your attorney as well. Sometimes you can apply for adjustment of status and the I-140 applications at the same time if your priority date is current. We generally don't ask people to do that because especially for the EB-1 process, the I-140 is a subjective application. There is a chance of denial. So if you apply for the EB-1, I-140, and the I-485 applications and you are denied, all of those applications will be denied. The I-140 and the I-485 applications will be denied, and that means you've spent quite a bit of money for those applications and not gotten approved. So our advice generally is to first apply for the EB-1 I-140, get that approved, and then you know that you won't have, or you should not have, an issue with applying for the I-485 application. You can track your cutoff dates against your priority date monthly at the visa bulletin. I have the links here, as well as the USCIS, as I mentioned before. So it's important to track that. We track those for our clients monthly to make sure that as soon as the priority date becomes current and their eligibility to apply for adjustment of status, we want to do that as soon as possible. Keep in mind that even if a priority date becomes current in 1 month, the next month it can go back again. So if your priority date becomes current, you need to move very quickly to be sure that you apply in the month that is current, so that you don't get caught so that you don't get caught not being able to apply the next month because the priority date has gone backwards. All right, so that concludes the information that I wanted to present to you today. I do want to answer any questions that you have here. Now is the time if you'd like to indicate or give us your questions. As I mentioned before, if you scroll down your screen, you will see a panel that says ask a question. So if you could just type your question there instead of the chat pane. So if you type your question there, I will take a few minutes to answer those questions. If I'm not able to get to the question, then certainly feel free to email me as well. I do have, it looks like, one question. Question is, can a Mensa membership qualify as one of the criteria for EB-1A? That's one part of the question. And we haven't run across that Mensa membership as one. It generally is not considered to be a professional membership in the sense that what the government is looking at is the fact that because of your professional accomplishments, not necessarily your IQ or your ability to, or how well you've done on exams or something like that, is not really a membership that they're looking at. They're looking at membership based on professional accomplishments, because keep in mind what they're trying to see is if you are recognized by others in your field as being outstanding or as being extraordinary. Another question is, what qualifies as a commercial success in performing arts? So oftentimes you can look at if you're a recording artist, your record sales. If you're a performing artist and you're on tour constantly or in demand on tour. If you are, I guess, an artist of visual arts, how well you've sold your artwork or have been on exhibit throughout the country. The other question is, does this have to be in the US? And the answer is no. As I mentioned with EB-1A, we're looking at national recognition in any country. So if you've received national recognition in another country, then that's what we're going to focus on. It does not have to be in the US. The next question I have is, the question is how a spouse from a different country of birth can help in accelerating a wait time. Can a child born in a different country help too? To answer the second question, no, a child's country of birth does not affect your eligibility or your which queue you're in or which quota you're under. So, for example, excuse me, if you're born in India and your child is born in Canada, it does not matter. It does not affect that. However, if you're born in India and your spouse is born in Canada, then you can put yourself into the Canadian wait line as opposed to the Indian wait line. And in that case, more than likely, it's going to be much faster in any category, EB-1, EB-2, EB-3, than would be the Indian country of birth. Another question is, does W-2 have to be presented as evidence for high salary criteria, or is a job offer letter for a proposed job sufficient? Well, a W-2, if you don't have a job offer letter that meets the criteria, then a W-2, paychecks, proof, tax returns, these are proof that you would have to provide to show that you did indeed have a high compensation. So that would be the best opportunity there, or the best evidence to prove that you meet the high salary criteria, is having a W-2 or a pay stub, or if your current job doesn't have a doesn't meet the high salary criteria, a job offer letter could also be sufficient if you're planning to change jobs and that new job does meet the high salary criteria, but you haven't yet been employed there. Okay. Oh, I'm sorry. There's a question there and I kind of missed it. Okay. There's one question I have. Can you travel abroad on an employment authorization card that you received before the adjustment of status of your green card? If I understand it right, can you travel abroad on, well, and the card says it serves as I-512 advanced parole. So the cards that now in most cases are being issued are what's called the combo card, which means that it serves for purposes of work authorization as well as travel. So if you have a combo card that says I-512 advanced parole, then yes, that is the card that you would use to travel abroad and return with that card to enter the US without a visa. So if you have that card, you don't need a visa. When you return back home, back to the US, you have to show that card in order to gain re-entry into the United States. I'll answer just a few more questions. Okay, regarding the salary to be high, should it be high in my field or high in terms of the US national average? And that's a good question. So it's actually a comparison of your field. So if you are a physician, specifically internal medicine, for example, then you're going to be looking at the national average for internal medicine, not the national average of overall the U.S., regardless of occupation. Another question, is a birth certificate mandatory criteria for a green card and EB-2, or is there an alternative document that can be produced? Now, for any green card application, a birth record is required. If you do not have a birth certificate that was issued close to the time of your birth, then there is alternative documentation. Your attorney should review that and give you, evaluation of whether your alternative document qualifies. But in general, you do have to have either a certificate of non-availability from your home country, basically saying there is no birth certificate available for this individual, or you can have a late filed birth certificate, which means you go and record your birth now, and you get a birth certificate that is recorded as of today, for example. You can submit either of those two. However, you also have to include another older record that establishes your date of birth and your parentage. So some of the qualifying documents for this, these older documents would be a primary school or elementary school record that has your name and date of birth and perhaps your parents' name. It could be a hospital record that was issued at the time of your birth. It could be a religious document that is typically used to record birth. But most of the time, most people use what's called an affidavit of birth, and that is a notarized letter from individuals, could be relatives or friends who are familiar with your birth date. You need two of those affidavits of birth, which confirm that you were born on whatever date and your parents are, and names your parents as well. So it is birth information is mandatory, but it doesn't necessarily mean a birth certificate. You can use alternative documents if you have to. All right, I think that's the end of our questions for today. I do want to conclude with letting you know that this information that we provided is general information. We provided this as, again, general information and not legal advice, because you really do need to consult with an immigration attorney to really get the right advice for your specific circumstances. Everybody's case is different, no matter how it looks the same. There are differences that an attorney should be able to discover and advise you appropriately as to your specific case. If you do need an evaluation or would like an evaluation of your specific eligibility for EB-1 or some other immigrant visa category or green card category, please feel free to contact us to schedule a consultation or case evaluation meeting. These are the ways that you can contact us to do that. And as part of the case evaluation meeting, we will look at your CV. We will ask questions and get background about your immigration history, your goals, and of course, the necessary criteria to determine whether or not you're eligible for any category of green card. So be prepared for at least 30 minutes to go through a case evaluation meeting, and afterwards we will give you our assessment as to whether or not it is a good fit for you to work with us or to apply for EB-1 or any other visa category. Again, I want to thank you today for attending. This session will be recorded and you will receive it via email. If you have any other questions, feel free to contact me at ann.badmus@solidcounsel.com. Thank you and have a great day.